Hello, good morning, everyone. Welcome to the first live webinar brought to you by Master Builders Association Malaysia, MBAM, on the topic of contract administration issues due to pandemic COVID-19. So we have received quite a number of questions. So we will actually start in just a few seconds, but this is a reminder to you, all right? If you have signed in with your Microsoft account, that is great, but if you have signed in as anonymous, we kindly request for you to actually end your queries or your comments with your name and organization so that we know who we are speaking to. Okay, and for today's session, we have the panelists from Azman, Davidson and Co, Mr. Rajendra Navaratnam, Ms. Chu Aili, Ms. Karen Ng, and we also have from Kheng Advocates, who is the founder himself, Mr. Chan Kheng Ho. From BK Entrusty, we have Surveyor Ong Hock, and also our moderator today, Mr. Oliver Wee. But last but not least, we also have our guest speaker, Engineer Harbans Singh. So once again, if you have any questions, if you're signing in from your web browser or your Teams application on your laptop, you can actually drop in your questions on the right panel at the Q&A tab. And if you're viewing us from your mobile, you can actually check out the top right corner. So without any further ado, I would actually hand over to Mr. Oliver Wee, our Vice President and Chairman of Contracts and Practices Committee. Mr. Oliver, over to you.
Thank you, Chien. Well, good morning, ladies and gentlemen. Well, welcome to today's forum on contractual issue due to COVID-19 pandemic and the impact of the movement control order, as well as the resumption of work for the construction industry. Now, since March 18, 2020, all construction work has been halted upon the enforcement of MCO, which is a measure to curb the spread of the coronavirus. But based on this, construction project could have stretched beyond its original completion date. We all experienced how the economy been affected adversely in the past 1.5 months. In fact, IMF was reporting that world economy would contract by 3% in 2020, which is more severe than the last recession we had in 2008. The enforcement of MCO is progressively disrupting the construction site across the nation. As for the construction and its related industry, contracting parties require clear guidelines to deal with all the uncertainties. Today, the panel speaker will discuss and share their views on common issues that contracting parties are facing and how the parties could mitigate and seeking for amicable solution together in order to move forward. Now, without further ado, we shall first respond to some queries that we have received from our participants this morning. Now, these are the areas where contractors are looking for answer. Extension of time under force majeure and frustration. Allow me to introduce Ms. Chu Aili and Ms. Karen to deal with these topics. Ms. Chu, please.
Good morning.
Yes, Ms. Chu, please go on.
Okay, good morning, ladies and gentlemen. Can you see my slides?
Yes, yes.
Okay, in January 2020, the COVID-19 first arrived on our shores. Initially imported, then eventually local clusters emerged. On the 11th of March, the WHO declared a pandemic. On the 16th of March, the government of Malaysia issued the movement control order. This would be later known as the MCO Phase 1. During the MCO Phases 1 and 2, the construction sector was shut down virtually except for critical works. The 14th of April marked a new phase in the MCO as well as for the construction sector. Specific work types and projects were allowed to operate with MITI approval, subject to stringent SOP, among which was that only 50% of the workforce was allowed to be working. And this, of course, has a lot of implications, including adverse effects on productivity. This coming Monday, 4th of May, would signal a new phase, the conditional MCO phase. It appears that the construction sector is allowed to operate subject to compliance with MKN SOPs, and it would appear that 100% of the workforce is generally allowed, except in a very limited situation concerning the installation of certain equipment. Although the 12th of May is the scheduled end of the MCO, however, there is a very strong likelihood that there will be stringent SOPs to be complied with by the construction industry. And all this may have impact on productivity as well as costs. One of the concerns of contractor, they feel that this difficult period is more than just a lockdown in terms of the physical work. They feel they are locked down by the contract, and they feel that the time has been ticking against them. So a lot of contractors have this question in their minds: is the contractor entitled to EOT? The short answer is that it depends on the contract EOT provision. And I would advise contractors to study their individual contract provisions carefully, including in particular the amendments to the provisions. There are some common delay events that the contractors should consider to see whether it would assist in the application for EOT, and first of all, whether he's entitled to EOT, and secondly, to rely on for the application for EOT. The first of these categories are the provisions relating to force majeure. Some contracts do not use the term force majeure. However, they are provisions that relate to the events that are outside the control of the parties. Secondly, compliance with law or order of authority. Thirdly, contractors' inability to procure. And lastly, architects or SO's instructions. For government projects, the PWD 203A, a commonly used form, has an EOT clause in 43.1. There are three possible delay events for the contractor to look at. First, A, force majeure. However, clause 58, defines clause majeure as an event beyond control of both parties and uses these limiting words, which are, and lists a number of specific events. And it is to be noted that epidemic, pandemic, as well as law or order of the government are not included. Secondly, I, inability to secure goods, essential materials and services. And lastly, SO instruction issued under clause 5. For government projects, there is some guidance given by the Treasury and the Finance Ministry to the SOs for the projects. And in the Finance Ministry guidance, it appears that SO are asked to issue instructions to suspend work on the basis of clause 58 force majeure. In the Treasury guidance, SOs are asked to do EOT assessment on the basis that there is automatic entitlement to EOT. And the assessment is to include the MCO period, as well as other factors such as mobilization, demob, site preparation, etc. It is heartening that the government appears to be instructing SO to give the most reasonable period of EOT to contractors. And the SO is given that duty to issue the EOT notice to the contractors. What about private sector? A commonly used form is the PAM 2006 form. Clause 23.8 of the PAM form provides for a number of delay events, and there are 5 that a contractor could look at. Firstly, force majeure. In contrast with the PWD provision, Article 7 AD of the PAM appears to specifically include circumstances below control of contractor that are caused by governmental action or epidemics. So this is good for the contractor in that they can rely on this clause. What about other provisions? D talks about lockout affecting trades. However, the wording of this provision appears to be more restrictive, talks about civil commotion, strike or lockout. And the ordinary dictionary meaning of lockout is that an employer preventing workers from entering a workplace until they agree to terms, which does not seem to apply in a situation like ours. P, the contractor can look also at P, compliance with change to law, as well as W, suspension of works by appropriate authority, both of which seems to be more appropriate. Lastly, the contractor can look at G, compliance with AI under clause 21.4, and but this AI has to be issued under clause 21.4 for postponement or suspension of work for a period not exceeding continuous period of 3 months. The PAM Pertubuhan Architect Malaysia has issued an advisory note to architects dated 18 March. In that note, it appears that architects are asked to issue notices to contractors to comply with the MCO under clause 4.1. However, PAM appears to recognize that contractors are entitled to EOT under clause 23.8a, force majeure. Although PAM does not recognize other delay events, contractors are advised to look into them. There is a word of caution: contractors must comply with procedural requirements. And for example, clause 23.1a talks about notice of intention within 28 days of commencement of the delay event. Contractors have to put their minds that there could be more than one delay event involved throughout this MCO. For example, first, the MCO that resulted in total stoppage of work. Secondly, during the third phase of the MCO, some of the contractors could have gotten approval to start work, but with 50% workforce, which affects productivity. That should be borne in mind as a possible relevant event. And even after the this phase, contractors should put their mind as to whether there are any subsequent events. And all this may entail the need for different notices. Okay, this is if the EOT clause can assist a contractor. But some of you may ask, what if my EOT clause does not seem to have any particular delay event that will assist me? Is there any principle of law that I can rely on? My colleague Karen will address this.
Ms. Karen. Thank you, Ms. Chu.
Okay, all right. Good morning, everyone. I'll discuss with you the principle of force majeure and the doctrine of frustration. Yeah, just to give you a general knowledge on these principles on force majeure and doctrine of frustration. Firstly, can you share your screen on my PowerPoint presentation? All right, next slide, please. Firstly, next. Yeah, so what is force majeure? There is no general rule as to what constitutes a situation of force majeure. Whether such a force majeure situation arises would all depend on what the parties in their contract have provided for. Okay, next. Next slide. Meaning, force majeure, there is no general rule on this principle. There is no general law on this, but it all depends on whether your contract contains such a provision on force majeure. All right. So what is the usual intent of a force majeure clause? To excuse contracting parties from contractual obligations and liabilities while they are prevented from performance, either completely or sometimes partially by defined events or circumstances. There is no fixed form of force majeure clause. Okay, so therefore, COVID-19 pandemic does not automatically qualify as a force majeure event under a contract. It all depends on the wordings of a force majeure clause in each particular contract. Okay, next. In short, you will need to check whether or not you can rely on force majeure to claim for EOT. You need to check your contract, whether your contract contains a force majeure clause, and if there is, whether the force majeure clause is wide enough for the COVID-19 pandemic to be qualified as a force majeure event under the contract. Like what Ailey mentioned just now, for PWD contract, the force majeure clause does not include epidemic or pandemic. Yeah, but for PAM form contract, it does include. Okay, and lastly, you need to also check whether your contract allows you to claim for EOT and loss and expense based on the force majeure event. Okay, it all depends on the wordings of your force majeure clause. Okay, all right, so that's all for force majeure. So what is a doctrine of frustration? Section 57(2) of the Contracts Act 1950 provides that a contract to do an act which, after the contract is made, becomes impossible or by reason of some event which the promisor could not prevent unlawful becomes void when the act becomes impossible or unlawful. I know you may find these wordings difficult to understand, so I'll give you some illustrations. So my next slide. Okay, these illustrations are contained in the Contracts Act itself. I believe you understand after reading these illustrations. Okay, A and B contract to marry each other. Before the time fixed for the marriage, A goes mad. The contract becomes void. Okay, so this is a situation where there is a frustration of contract. Okay, second illustration, A contracts to act at a theatre for 6 months in consideration of a sum paid in advance by B. On several occasions, A is too ill to act. The contract to act on those occasions becomes void. Okay, all right, next. Okay, now the question is, can you, a contractor or the employer, claim that the construction contract has been frustrated? Okay, next. You need to prove 3 elements. Okay, these 3 elements must be present in your case in order for you to claim that your contract has been frustrated. First, no provision has been made in the contract for the event upon which the promisor relies as having frustrated the contract. Okay, so I believe this first element could be easily satisfied. Second, the event relied upon by the promisor must be one for which he or she is not responsible. Please take note that self-induced frustration is ineffective. Okay, I believe this also could be fulfilled, could be easily fulfilled. But let's look at the third element. The event which is said to discharge the promise must be such that renders it radically different from that which was undertaken by the contract. The court must find it practically unjust to enforce the original promise. Okay, this, the third element may not be so easy to prove. It all depends on the facts of each case and also depends on the court's interpretation. Okay, all right, next. Please take note that a contract does not become frustrated merely because it becomes difficult to perform. Like for instance, now we have this COVID-19 pandemic, and because of these SOPs imposed by the government, make you more make it more difficult for the contractor to perform the works, but it doesn't mean that a contract will become frustrated, okay? And the doctrine does not apply just because the promisor's obligation has become, because of change of circumstances, more onerous than what he has contracted for, okay? Next. So what is the effect if a contract is frustrated? The contract will be void and the parties shall be discharged from performing the contract. The restitutionary remedy is provided for under Section 66 of the Contracts Act. It provides that when an agreement is discovered to be void, or when a contract becomes void, any person who has received any advantage under the agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it. I did not put in my slide that in fact there are two provisions which are applicable. These two provisions are found in the Civil Law Act 1956. These are sections 15 and 16, where section 15 provides for adjustment of rights and liabilities of parties to frustrated contracts. You can have a look, you can Google for this Civil Law Act 1956, and you can look at this section 15. But please take note that this section 15 is not applicable to certain contracts, and this is provided in section 16. Okay, all right. That's it. That's my presentation. Thank you.
Thank you. Thank you, Karen. So it's very clear that frustration means impossible to carry out rather than difficult to carry out. Well,
Yes.
So far we have dealt with the extension of time by Ms. Chu and Ms. Karen. Thank you so much. And now we are on the next most interesting topic as well, loss and expense claim. Mr. Chan Kheng Ho shall deal with the queries that raised by the participant on this topic. Kheng Ho, if you please.
Okay, thank you. I was speaking in a muted position. Hold on. Let me just start the time. All right, so good morning, everybody. We are going to be talking about loss and expense claims due to the MCO. And here we are seeing what we will cover. First of all, we will consider some general principles concerning a loss and expense claim. And then I will look at loss and expense claims under the various standard forms. There were some questions put in earlier before the webinar that asked about specific items as to can we claim A or B, PPE, and so on. So the thing is, in order to claim the specific items, we need to be entitled to loss and expense first and foremost. And once you are entitled to it, then whether you are entitled to claim the specific items is for you to prove on a case-by-case basis. So the general principles of a loss and expense claim will kind of cover this situation. And there was also a question put in about acceleration costs due to the MCO, which will also be covered here. Fazli, next slide, please. So here are the general principles. A construction contract basically allocates risks between parties. So you have contractor risk events, you have employer risk events, and obviously items within any party's control ought to be that party's risk. That is the general principle. Now, the problem is we have a lot of events that are neutral events like the COVID-19. Nobody is at fault. I don't think we have any employers or contractors who are like Donald Trump. This is COVID-19 was caused by you. You brought COVID-19 to us. So it's a neutral event. It is not within the control of either party. It is both an exceptional circumstance as well as it has led to certain changes in the law in terms of the MCO being imposed, in terms of SOPs being imposed on parties. So the question is who bears the risk of these neutral events? And that depends very much on the terms of the contract. Next slide, please, Fazli. So first of all, let's look at the PAM contract, which is very widely used. Loss and expense claim under the PAM contract. Let's start first and foremost by saying contractor has the obligation to comply with the law, and that's inside the PAM. And the interesting thing is, if there is a change in law, just as in this particular case, the contract is running halfway, then the MCO comes in, SOPs come in. If there is a change in obligations, it is relevant for purposes of extension of time under clause 23, but it is not relevant for purposes of a loss and expense claim. So how then does a contractor potentially argue for a loss and expense claim? Because if you are relying on force majeure, you are not entitled to loss and expense. So there are a few limited circumstances that you possibly could argue. One is if it is a situation where the employer has another direct contractor and the direct contractor is lacking in progress. Obviously, he will be lacking in progress because of the MCO, and you could then fall under this clause 24.3 sub A to say a lack of progress of other contractors directly engaged by the employer leads to a loss and expense claim for me. Or secondly, if there is an agreement that the employer would supply the materials, employer clearly wouldn't be able to supply materials at this point in time, so it leads to a loss and expense claim for me. Or if you are so lucky that the architect decided to issue an instruction under clause 21.4 to suspend work. So the MCO got announced suddenly, it was sprang upon us. I believe they gave us like 2 days notice, and a very zealous architect decided he will give an instruction under clause 21.4 to tell you to suspend works. In fact, he doesn't need to give that instruction, but say he does. Then you may argue that his instruction under clause 21.4 triggered a potential for you to claim loss and expense under clause 24.3 sub D. But there is a problem there. The problem is, did these issues, the lack of progress of other contractors, failure to supply, or an architect's instruction, did these issues materially affect the progress of works? Because after all, even if the supplies were there, you couldn't continue with your works anyway. Even if the supplies were sitting on the site, you were suspended by reason of the MCO in the first place. So these things may go towards issues of quantum. For example, when the MCO came into the picture, you were suspended anyway, so therefore the lack of supply by the employer is not the material cost for your delay. However, when the MCO is lifted coming this Monday, the supplies are not going to automatically appear on site. So there may still be continued lack of supply of materials. Therefore, at that point in time, maybe you could say, hey, I am now suffering loss and expense under this particular clause. I have had some questions come to me about, is this a variation under clause 11.1 sub D? Because it is a limitation of work hours, it is a limitation of workspace. The problem is clause 11 is for variation. Variation requires changes in the provisions of the contract. And so unless your contract has provisions specifying work hours and workspace, the fact that the MCO came in may not, I think, be a change in the provisions of the contract itself. Okay, that's for PAM. Fadzli, next please. Now we go to PWD. Again, we start with a very basic principle. Contractor is to comply with the law, and for PWD, there is actually a clause that says, including all health requirements during epidemics. So there were questions coming in about, hey, how about cost of sanitization? How about cost of PPEs, etc.? All these costs of compliance with the MCO. Well, if you're under a PWD contract, this is actually an obligation of the contractor to comply with health requirements during epidemics. So again, how do we argue potentially? Well, if there was an instruction to suspend works under clause 50, if that was given, potentially that could be the basis for you to argue that you are entitled to loss and expense as the trigger for a loss and expense claim. Again, a lack of progress of other contractors is a trigger for a loss and expense claim, but the same questions would apply as in PAM contract. Are these issues the cause of delay? Were these issues the cause of delay during the MCO? Perhaps these issues would be a cause of delay after the MCO is uplifted. There is a clause 5 instructions by SO, but that clause 5 is tied to instructions necessary and incidental to completion of works. There is a clause 21 on variations arising from change in law, but it is variations that are necessary to the works. So it becomes arguable whether a reference to works also mean work conditions, because the MCO does not really change your works, it changes your work conditions. All right, next. Under IEM, Under IEM, there is a clause on employer's risk. Clause 20.4, it includes this phrase, any operation of the forces of nature which an experienced contractor could not have reasonably foreseen. So does COVID-19 qualify as a natural event? I had a client who said, of course, because viruses are part of the natural world. So of course it is a natural event. Well, one thing I would say, it is good that the IEM contract did not elaborate what are natural events. In the PWD contract, there was elaboration of tsunami, earthquakes, natural disasters were elaborated. IEM did not elaborate, so the ejusdem generis rule does not apply. The ejusdem generis rule is a rule in law that says if there is a series of 4 or 5 terms used, then you must interpret the clause using the same category. So can you say that coronavirus issue is the same category as a tsunami, as an earthquake? I'm not sure, right? But whether you can say that it is a natural event, that is arguable. But on the other hand, there is a clause 8 in IEM that says contractor is obligated to ensure the safety of all operations on site. So here we are talking about loss and expense incurred as a result of MCO, as well as the ensuing SOPs. Is it a caused by nature, therefore it is an employer risk event, or is it a matter of safety at site, therefore it becomes a contractor risk event? That is a question to which I have no answer. It is arguable, and if it is an employer risk, then of course you can claim costs under clause 53. Next. And finally, we come to FIDIC. I know that FIDIC is not as well used as generally used as the rest, but we do want to end with some good news. FIDIC requires a contractor to comply with the law, but allows the contract price to be adjusted to take into account any change in laws. So FIDIC seems to put a situation of an adjustment of contract price to be very likely. Next, please. Now we come to the issue of acceleration. There was a question on acceleration. I just want to briefly explain there are 3 types of accelerations. One, is it an acceleration by the contractor to cover up the contractor's own delay? That is a catch-up situation. And for that situation, you have no entitlement to claim, as you can imagine. Secondly, is it an acceleration at the employer's request to cover a delay not due to the contractor, for example, COVID-19? Now, if your contract allows for acceleration, then you will be paid for acceleration costs according to what the contract has provided. If your contract did not allow for acceleration, then acceleration costs should ideally be agreed upon by parties beforehand. Otherwise, the contractor really has no obligation to accelerate. And thirdly, there is this issue of constructive acceleration. This is when a contractor asks for extension of time, the employer wrongfully denies that extension of time, but then the contractor is looking at the liquidated damages clause and he's saying, hey, there is this risk of 100,000 a day. It is too high a risk for me. Because the employer wrongfully denied my EOT, I am going to accelerate on my own in order to meet the completion date. So this is constructive acceleration, and it is claimable. The acceleration cost will be claimable according to general principles of claiming damages. Next, please. So in conclusion, EOT is almost a certainty for every contractor due to the MCO, but loss and expense is a totally different proposition. It is difficult to claim under PAM and PWD unless there are certain unique circumstances that happen to apply to your case. It is arguable under IEM whether it is a force of nature. It is likely for you under FIDIC. With a big disclaimer, the assumption is you have not amended your standard forms so drastically. Otherwise, effectively, you're having a bespoke contract and every contract will have to be considered on its own terms. There are express clauses in nearly every contract obliging the contractor to comply with the laws, and with those express clauses, it makes implied term arguments difficult. That means it's difficult for you to say, when I entered into the contract, there was an implied term that there wouldn't be such a drastic change of the law to impose all these hindrances to me. Implied term arguments become difficult because of the express clauses saying that you have to comply with the law anyway. So what is the way forward? The way forward perhaps does not lie within your contract. The way forward perhaps is for parties to look beyond the contract for a win-win solution, because after all, your employer also have an interest to complete the project. They have got financing costs that is ongoing. The licensed housing developers have got obligations to end purchases, and they cannot get extension of time for that part of their obligation. So they have an interest to get the project completed, and that could be the impetus for both parties to sit down and have a friendly discussion together. And that is all from me. Thank you, Oliver.
Thank you, Kheng. So lots of thoughts and understanding are required on your individual contract provision before you make a valid claim on loss and expense. Now, after hearing from 3 speakers on the subject matter on extension of times, loss and expense, but not forgetting the contractual obligation is as important. Contractual obligation under MCO, as what this morning Mr. Raj is going to share with us on this specific area, contractual obligation with the title of to work or not to work. Mr. Raj, please.
Yeah, thank you, Oliver, well, thank you for the previous background to this. Well, a very common question that is on every contractor's mind, in our view, is that there are several risks of starting work. Now, earlier on, it was subject to an application in the previous phase of the MCO. Now, in this sort of situation, presumably the contractor could go through the motions of making an application, and it was more of a mitigating situation. Now the situation has changed yesterday, because now you can work. You don't need to make an application, and now you're allowed 24-hour working, 100% workforce, but subject to conditions. And some of the important conditions that have been imposed, you need to adjust the number of workers on site to allow for social distancing. You need to arrange for work scheduling, staggering of work, etc., again to the same intent. You need to comply with all the SOPs by the Ministry of Health, etc. You need to be responsible for the medical costs of workers infected by the COVID-19. Now, this one was actually clarified by the Ministry of. There was a series of questions posed immediately after the announcement, and they clarified that medical costs are still the responsibility of the contractor. So now, what do you do? Because there are very, very significant risks if you start work. But at the same time, there is a contractual obligation to work, because the contract is on foot. The contractual obligations remain, and you have to honor the contract. The practical problems are this. Obviously, there's cash, because the thing is, contractors, subcontractors, etc., have had to be in a situation where, for the last couple of months or so, they have had to carry their workers. They probably now to start. They probably need cash, and where's that cash going to come from? Employer, strictly under the terms of the contract, is only supposed to pay in accordance with the contract. Advance payment for remobilization can only come about by agreement, and this is something that as the Kheng just mentioned earlier, it needs to be something that needs to be discussed with the project owner. And in fact, one of the questions posed that came in on the chat as well was, this is an industry-wide problem, and there needs to be an industry-wide solution, because there are many other people involved. There are the banks involved, there are the insurers involved, the contractors, supply chain, the employers. But I think the key thing is that I think decisions now need to be taken in the interest of the project, not on each individual's contractual rights, because that is going to be a very destructive way of doing things. Now, at the end of this session today, we are going to be discussing some possible solutions. But in the meanwhile, I would say that perhaps on a micro level, on a project level, the architect has a big role to play. The architect or the supervising officer, whoever may be the contract administrator, has a very big role to play, because he's the one who can actually persuade all parties to hold their fire and try to find an equitable way forward to allow the project to proceed. Can we just move to the next page, please, Fazli? Now, extension of time and loss and expense, both of these have been covered in some detail by the previous speakers, so I won't dwell on them too much. Now, what I will come to talk a bit more would be the situation where if the contractor decides for commercial reasons, or the fact that he really simply cannot afford to restart, what does he do? I mean, effectively, he would have abandoned the works. Now, if he has abandoned the works, then he runs the risk of being sued by the owner or the main con in the case of subcons. Now, Karen earlier on mentioned the doctrine of frustration, and she talked about the legal definitions of the practical of the doctrine of frustration. But it is arguable, in my view, that you can perhaps say that this converts the contract into something very different from what you entered into, because conditions such as social distancing and then the productivity assumptions that were entered into, the resources required, all of these are very different now because of the conditions imposed on coming back to work. So in this situation, it might be arguable to say that that the contract has been frustrated if you have to defend it. It is a very high risk option to take, but sometimes you may have no choice, and if you have no choice, this is the only defense you can bring up. And there has been an Australian case, in fact, this case of Codelpha. Fazli, can you move the page down, please? Yes, go further down. No. Yes, there's this case of Codelpha where there was the contract was said to be frustrated, where the contractor had planned to do its work in a certain manner, in a certain approved program on certain days of the week, but he was prevented by an injunction which prevented him from working because of nuisance to the surrounding neighborhood. Now, the High Court of Australia actually held that and the High Court is the highest court of Australia, by the way, held that the contract was effectively frustrated. This is a little bit. This case hasn't found even in Australia a universal acceptance, but a subsequent and more recent High Court of Australia case is actually endorsed the approach taken by Codelpha. So it is a decent argument to take. The only concern we have is we have the Contracts Act here, which Karen has talked about, but the way that the Section 57(2) of the Contracts Act, which has been understood to deal with frustration in Malaysia, the cases have been interpreted to show that it must so radically change the nature, not merely the expense or onerousness of the contract. So it could be very fact sensitive. But I would suggest that in a situation where this extraordinary situation that we have, where you have almost 2 months of non-working and therefore non-payment, and then you're asked to remobilize your workers and your machinery and all that, which is going to involve some more significant costs. And then even when you come back, you are exposed to having to work under very restrictive conditions, which impact upon your productivity. You take severe risks as to the medical costs that may come about if there's an infection. All this may change the very nature of the contract. It is a decent argument. I won't say it's a match winner, but at least I would say you have at least a 50% or slightly better than 50% chance of success if you're forced into this situation. But I would emphasize that it is a high risk option, and in this situation, I am suggesting that perhaps if it came before the courts are likely to be sympathetic to the plight of the contractor. So in summary, Fuzzy, move it down to the end. Yeah, in summary, there are great commercial challenges which face contractors to take the decision whether to come back to work or not. Most contractors will probably have to bite the bullet and come back to work. It would be helpful if there could be some collective agreement with all parties involved to generate some cash to allow them to do so if they are seriously in distress. And this ideal situation would be an agreement with all the stakeholders. If no such agreement is reached, then obviously the contractor must weigh the risk, whether or not he takes he has to take the loss on the chin if he's in a position to take it. If he's not in a position to take it, that decision is made for him. He just simply cannot come in. And if it's not possible for him to come back again, then he may have some arguments to defend a claim again, by the employer or main contractor on the basis that the contract has been frustrated. And that brings me to the end of my segment of this webinar. Thank you.
Well, thank you very much. Thank you very much on sharing on your to work or not to work. Now, after hearing all this, to know more on the MCO working and SOP is equally important, and it is a current and continuous event with or without the MCO. Now, I would like to invite HD to share his expertise on this subject matter. HD, would you please?
Yes, just hold on there. All right, let me load the slide first. Can you see?
Yeah.
Good. Good morning, everybody. This is an interesting time because I prepared the talk, and then yesterday a lot of things changed. But of course, this is a welcome change because we are talking about restarting the Malaysian economy, and that will be on Monday, 4th of May, where the Prime Minister yesterday on Labor Day given us a good present to say that we can go back to work, and allowing many industry and businesses to operate, of course, subject to conditions. And what it is that this clearance is subject to the readiness and compliance with SOP, which is the SOP for restarting the economy. And this SOP is to ensure that all health-related aspect is prioritized, and to ensure that there is lower transmission of the risk of COVID virus, as well as causing more burden to the national health services. So, of course, it doesn't bar the government to come back in the event there is high transmission. They'll go back to the movement control that which we have been experiencing over the 40-odd days, or rather until tomorrow. And this restarting of the economy is in sector, is done in phases, and there are some sector that is not allowed still, and those that is allowed, you have to comply with the SOP, in failing which you may be subjected to legal actions, including the revocation of your operations. So this new norm, we call it the new norm in business and life, or the whole society approach, WSA, basically is, now all this is done in English. The handout is actually given, the SOP Pembukaan Semula Ekonomi is in Malay, and is issued by Majlis Keselamatan Negara. So you can see that some of the key points are take healthy steps, social distancing, wearing masks, encouraging a high level of cleanliness practice, washing hands, preparing such facilities to workers and customer, ensuring that the premises is sanitized, practicing prevention of infections, looking at the symptom monitoring, prevention of infection protocol. I'll show you some of those slides which was given in Malay shortly. There are many requirements, and you are also required to report to the health department if there's any COVID infection. So you find that the employer is also obligated to train workers to observe and act when any COVID symptoms is recognized or suspected. So the other key point is, of course, to avoid any form of gathering. So social activities, certain social activities are not allowed, and you find that all physical contact sport activities are not allowed. Thank goodness golf is allowed. So any ceremonies, kanduri, open house, religious activities are also not allowed. Now, this is the part of the ban activities. These are all in Malay. I'm sure many of you would understand in Malaysian. But the principle behind this banning of these activities lies in here, where they are talking about controlling crowds. So those that's difficult to control, possibility of droplet of exposure, difficulty in controlling behavior, possibility of close continuous contact, like swimming pool, you are not, it is not allowed. Being in confined space is also not allowed. So there are quite a number of banned activities in the various sector that is not allowed, as you can see here, without me going into the details. Now, there's also this list of banned activities, and you can see that seminars are not allowed, face-to-face seminars, and certain equipments like the tower crane setup is not allowed, and those gathering which involve more than 10 person is also not allowed. So you can see there are also other areas, and you can see evidently the barber shop is also not allowed still. Right? Now, there are various sectors, and every sector will have one of this. And because this is construction, and I'm showing you this particularly related to construction, there is also one related to professional service. But for these purposes, I'm showing you the sector on pembinaan. You can see that it's governed by the Act 520 and also the perkhidmatan professional that is involved in the construction industry. And semua aktiviti dibenarkan. And you can see that that is all activities are allowed. Capacity pekerja 100%. And operasi di kawasan those what do you call that lockdown area is not allowed. And you find that you still need to comply with the SOP, which I'll share with you, the SOP by CIDB and JKR or KKM. And you need to comply with the Act 520 and Act 342, which is the Infectious Disease Act. And you can see the activities and protocol. What are the activities and protocol? And it's listed down 15 of them. I'm not going to go through all of them in detail, but I've summarized it in English afterwards in other slides. But you can see that what you're going to do with the workers, the transportation for the workers, how the workers' movement are going to be, and you find that how you're going to spread and those information, including posters, how you're going to manage and react to emergency, how you're going to deal with contact, and at the entrance of the site, what do you do, and during the work, what do you do during the work time, and what do you call that, latrine facilities, and during the break, what needs to happen, and when they go back from the work, and also their labor quarters, CLQ, and lastly on the records. So there's a stringent requirements on record on this. So of course it sounds a mouthful, but you can see that these guidelines and checklists are available in the website, CIDB website. the jointly issued standard operational procedures and guidelines documents available on CIDB website. And just to summarize, these are the general guidelines, the working time limits, and workers who just came back from overseas will need to be quarantined for 14 days. Virtual meetings are encouraged. If you look at CLQ, centralized labor quarters or living quarters, those are in document 2, and the workers needs to be fit and not showing any symptoms of COVID-19, and they need to download the KKM application MySejahtera for contact tracing, and the contractor needs to screen all workers by checking their temperature daily before getting into the vehicle to the site. So before they even go to the site, if they are on the CLQ, they need to get their temperature checked. So any worker's body temperature above 37.5, the contractor must arrange for medical screening and check with his company panel or nearest health clinic. So those showing symptoms must be isolated. And there is also a CLQ guidelines under document 3 that talks about reporting, quarantine, decontamination, safety and health, sanitation, which I will not go into the detail. Now, the other aspect of it is workers and material transportation. Again, they have to make sure that social distancing is practiced. Public transportation is not allowed. And contractor must ensure that employees' vehicle undergo sanitation and disinfection. Transportation must be within the same district, and contractor must inform all the suppliers to obtain, well, it was operational approval. Now you find that it's open. Following the KKM's COVID prevention measures, record any incoming materials onto the site, also to inform supply chain for material supply. No need approval now. Materials transporter needs to be screened, and use of hand sanitizer and record must be kept for inspection. So you can see that on the site there are also other requirements without going into the details, right? Approval letter was earlier required, now you don't require that. You must declare complete list of workers, and only workers that comes from the contractors provided transportation is allowed to enter the site. So there are stringent requirements here, but of course those 50% now don't apply now. This is the original SOP. You can also see that there's control entry point, social distancing, and those workers that is infected, contractor is responsible for the full cost of all medical expenses, decontamination process, and other related expenses. And even if you see, apart from the toilet, which are facilities which must be clean, which I mentioned earlier, your food preparation by the canteen is also under SOP. It must be wrapped in plastic, and the food provided must be also wear mask and glove. The food provider, that is, sorry. And workers must use the contractors provided vehicles to go back to their living quarters, and immediately when they reach there, they must shower and wash their clothing upon arriving at the living quarters. Now, these are the records that is required. One is the workers' record. You can see attendance, health screening, movement, personal details, site hygiene management records, toilet sanitization records, site cleansing records, site management records needs to be done, risk management. For those in ISO 9001-2015, you'll be familiar with this. Incoming, outgoing material supply service records, authorities inspection records, and all these records you must be made available at all times for inspection by the authorities. So it could be CIDB coming to check, CIDB officer and all that. You must have all these records available for checking. Now, one of the key thing that I'm in my presentation is this. Now, on the MCO working, the key elements and prerequisites. The earlier speaker has mentioned that we didn't have much time when we were told about this MCO being enforced. In fact, the official notification was given on the 16th of March, so many contractors was caught off guard. But having said that, China contractors and suppliers, you find that even as early as February, particularly after Chinese New Year, their Chinese New Year, the lockdown got extended, so many of them couldn't come back. By the time it was lifted, many of the cities were on lockdown. By the time it was lifted, on Malaysian side, they can't come in. So they are still having that problem as well. But for those contractors who managed to demobilize, I'm sure that you would have look at if you have managed to demobilize, issues like protection, what you're going to do with your mobile equipment, security, particularly your storage of your equipment, tools, etc., workers' accommodation, records. You have taken records, etc. And most importantly, before you have that MCO, whether you have done a joint valuation of work done and material on site or not, and deal with the issue, how are you going to communicate during the MCO, right? And for those who have at ISO process, you find that risk appraisal start to kick in. You then need to look at risk appraisal and assess those risks. So the order notification and instruction will be, the order is the MCO order, whether you have notified that the employer and the architects or the SO, depending on the form of contract, and PAM has advised what do you call that, principal submission person or the architect to give the contractor the instruction relating to the order, and if there's any extension of time and or loss and expense claim, to assess them or to evaluate them accordingly under the contract. So even at this point, the contractor must start getting the documentation ready. And now we come on to the MCO period, which we have 3 extensions. And the same thing applies. Every MCO extension, you need to give your notification. And during this period, of course, your mitigation that you need to provide for, some it's under what do you call it, in law mitigation, and in some contract as well. Your insurance and performance bond extension where applicable, and you need to maintain protection, security, and site safety, safety of the works, materials, equipments, right? For example, your tower crane needs to be what do you call that, restrained, etc. So the compliance with the order needs to be enforced. And during this period, for those who have a joint valuation, of course, the QS will then start doing the evaluation and architect doing the certification. If you have not done so, then during this MCO period, you can still submit your payment claim, because the MCO period is not a declared holiday, right? What you need to do is just stay at home, work at home. So this still progresses. And for those contractors, they are still have to pay their staff and workers, and to some extent their subcontractors as well. And over this period, many of them would face non-payment or lack of payment, and the issues on finance and advance payments would need to be considered. There are definitely disruption and delay claims, and this needs to be what do you call that, prepared. Likewise, loss and expense claims. So the key important feature is records. If you want to do a good claim, you must have good records. So during this period, risk monitoring and control, it's important, and documentation is the key. And many contractors and subcontractors has also engaged their consultants to make sure that all these documents are being prepared. So post-MCO, and for those who have applied and commenced work, and now when you're talking about the 4th of May, which is Monday, you find that when you go back, you will then face with remobilization issue. Again, notification needs to be provided for, documentation needs to be done, And I mean, I have even advised that write in and tell the employer, tell the architects that you're commencing work, you're doing remobilization, and you are also needing to provide your work program, which I'm going to talk in my next slide. But basically, compliance with SOP, which I'll deal with in the following slide. The work conditions needs to be dealt with. You need to unprotect if you have protected your work for you to start work. There will be, because it's almost 2 months, deterioration and need for making good. So some of the material may need to be replaced. Factories and Machineries Act need to be complied because your equipment, which is not operating, has been idling for 1.5 months, will needs to be serviced, needs to be maintained, and need to be repaired. Your temporary works needs to be checked to make sure that it's still safe. And if you haven't done any valuation at all, the first thing you go back to work next week is to arrange with the consultant and get a joint valuation of work, because that will show what happens at this point, or at least if it is if you have done it only at this point, will tell you that at this juncture what work has been done, what material has been delivered so far before you move on here on. So there are other issues as well: resource management, risk management, possible material increases, acceleration costs, which Kheng has mentioned, and issues relating to dispute. You cannot settle it amicably. I'll talk about it on the subsequent slide. Now, I know that I don't have much time, but you can see that this MCO, originally we need to apply, we need to get approval. So we need to go to MITI, we need to comply with SOP. There were criteria, there were requirements, there were application, and it involves the various parties to comply with it, and for the employer to collaborate and to cooperate, and for the consultants to contract manage the whole process as well. So now what has happened is this. Now with these new requirements, the application is no longer required. You go back to work, but you are still required to make sure that you submit your company registration, you do your Aku Janji declaration, that you would comply with the SOP requirements. So that is the requirements, but they don't expect you to do that before you start work on the 4th. And apparently, according to the rules, they says that you can apply in the course of next week. And I think until 12, if I'm not mistaken. So, but the more important thing is this: for contractors and subcontractors, the 5M will still apply. The only difference now is we are talking about new norm, not the original norm. When we can get back to the original norm, that is still a question mark. But there's definitely change in the work method, right? So in terms of, let's start with the first M, manpower. You look at it that the HQ side, the top management needs to decide, needs to lead, needs to give instruction to the site people to say, look, SOP needs to be complied, because ultimately the bosses are the one that Aku Janji, right? So the site team will have to make sure that the supervision will need to be put in place. And these are new norm supervision, not the original type of supervision that you have entered your contract into. So what I mean, the HSE requirement will now be very different, and all these will be governed by the SOP requirements here, right? Which is not the usual norm that we have. Then when we talk about money, for the contractor, 2 months, almost 2 months of no work, or rather 40 over days, your workers will be starved of cash. They need the cash. So the cash flow is important. There's need to look at the finance side, whether you need an advance or not. Whether for the employer side, they will need to look at and see whether they can pay advance, or if not, whether upon the valuation of the works, instead of taking 60 days or 30 days or whatever from the certification date, is to then say maybe a week or 2 to pay, or for that matter, tap on the retention to say that you can then release some of the retention to facilitate this cash flow. There is also other aspect of it. If the employer wish to accelerate the work, then instruction needs to be given to the contractor. There will be also likely to be increases in resource costs, which needs to be dealt with, and whether some compensation is to be provided for. For those who remember that in 2009-2010, when we have the sudden surge of steel bar price increase, there were consideration by the government, in spite of it, where there is no there's firm price contract without fluctuation. For those who remember, there were variation of price formula. We can kick in, some employer provided compensation for the contractor to continue to be the work. Otherwise, some of the contractor will say, you can take back your performance bond. I will lose more money than the performance bond. So under these circumstances, maybe there will be similarity on that. Some consideration will need to look at it in terms of whether it is extra sharp payment if loss and expense is not been given, and to look at that possible compensation. On the method, you can see that the method again will change. The work method will change. The original work program will not apply. There will need to be a revised work program. And PAM in its advisory note has advised the architect to request from the contractor the revised work program, taking into account the MCO plus the post-MCO, or rather the remobilization period. The method statement originally provided for would change also. So there is a need for a revised method statement, because your work method will definitely be slowed down because of the condition imposed upon the workers and upon the work, what do you call that, movement as well. So the emphasis, the key emphasis in this COVID-19 working procedure is health, safety, and welfare, so that you avoid or minimize the infection. So records is important, as I mentioned to you. And when it comes to materials, you find that for those who are protected, now you want to go back to work, you need to unprotect them. You'll find there will be some deterioration. There'll be some damages as well. Windows get broken and so on and so forth. So you will have issues of replacement, issues of new material, because certain materials that has been incorporated could not be used anymore. So you need to redo the work again and all that. So then the last point, of course, is machineries. Those that is idling, you need to maintain, need to repair and upkeep to make sure that they can be they can run. And of course, security aspect of it is important, because you don't want illegal workers coming in and contaminate the site. So this applies to manpower as well. Over here, securities. So over here, I've put here security as well. You can see the emphasis on securities, because one of the biggest issue is that the hidden bomb, I would call it the hidden time bomb, is those particularly the illegal workers, which are still, many of them, in hiding. And if they get back to the site and contaminate, then you will be definitely liable, because the government makes you liable for it. So in conclusion, if I may summarize, it's definitely an epidemic that has moved on to a pandemic. And Ying has mentioned to you about the chronology of when it happened. Both employer, contractors, and subcontractors will need to comply with the statutory order and regulations. There's no two-way about it. It affects almost every business industry, and that includes the construction industry. Force majeure events are admissible. The JKR, the Treasury has already said that the minimum automatic granting of EOT will be based upon the MCO period, and any further EOT to be granted will depend upon the pengarah or the SO concerned for the project to take into account of remobilization, etc. So those contract that has got provisions stating, like, for example, Epidemic Act of Government and or criteria compliance, like FIDIC, event beyond parties' control, would qualify. Other relevant provisions may also apply: authorities, orders, statutory requirements, architect SO instructions, and variations. Now, it's likely that a combination of the relevant provisions is necessary for both extension of time and or loss and expense claim, and the need for compliance with the contractual claims procedure mitigation efforts and documentation substantiation needs to be there to prove a direct causal link between cause and effects pertinent to such claims and its entitlement. So again, good records are essential elements for any contractual claims and assessment or and evaluations by the consultants involved. So I've mentioned about the SOP. You need to consider and adopt the MCO working, those key elements and prerequisites. The joint SOP is important. The contractor needs to manage the risk on site and compliance to avoid any action by CIDB under its Act 520 and the Act 343, Prevention of Control on Infectious Disease. So last but not least, contractor needs to submit claims, yes, but they need to be realistic claims, whether it's time and or cost. Consultants, they need to be professional and fairly assess, evaluate claims to avoid unnecessary dispute between the contracting parties. Employers need to consider not only the contractual aspect, but the commercial aspect as well, in order to come to a realistic claims settlement. I emphasize on commercial because this is an unprecedented event. The last time it happened was in 1918, the Spanish flu, and there's a lot of history recorded on it and how America reacted on it and so on and so forth. The history seems to repeat itself, but the commercial aspect of it needs to be looked at if the work were to progress forward. So whether there's a need to consider acceleration costs to compensate the contractor to bring back the work to its original completion date, or at least to mitigate the delay. So in the event there's no agreement, the negotiation failed, then the ADR method, particularly mediation and or expert determination, can be adopted for the settlement of claim. And on that note, I believe that the next speaker will talk on the mediation. Harbans Singh, please. Thank you.
Yeah, thank you, Mr. Ong, for your lengthy and clear explanation. Now, actually, with the SOP now, contractors understand that there will be further EOT is required after the MCO. Well, COVID situation is way beyond the contracting party's control. No one foresees and expects the virus would develop that fast and that damaging. Now, the right approach would be parties seeking the common objective and establish a workable plan to move forward, rather than dwell with the dispute. Now, coming up next, Engineer Harbans is to share his experience on a common platform for contracting party to seek for amicable solution. Uncle Harbans, please.
Good morning, ladies and gentlemen.
Morning.
I hope you can hear me.
Yes.
I've been assigned this graveyard shift. I'm the last of the topic because if you look at it, hardly we have got any questions to do with how to resolve disputes. I think most people at the moment are only interested how they're going to get their payment, their money, and issues like that, you see. So I think it is quite understandable. And you would also know I have not prepared any slides because I have a very limited time actually to talk. We are running out of time, you know. And what I'm going to talk about is a scenario which some of you may be facing now, but you're going to face it very soon, because now the immediate concern is to start and get your work going. And only after you've got your work going, I think then these issues are going to come up. But from my experience over the last few weeks, already disputes are coming up. Now, the question is, what is the best approach to take? As you know, the situation is very, very exceptional. I think it has not sunk into a lot of people that is very, very exceptional. We cannot be talking about contractual issues now. You know. So if you talk in terms of what claims and disputes and all that, I think we've got to forget about taking the conventional rights, you know, approach, enforcement of your rights, you know. Enforcement of your rights involve litigation, arbitration, adjudication, and all that. Now, let's face it, even you want to go to adjudication for now, the latest I heard from AIAC is you can register now your adjudication cases, but they can't appoint because they got another problem. They don't have a director or acting director. So adjudication, you can forget about it. Even if you initiate now, it's going to take you about 120 days down the line. And that is if there's not going to be an appeal. Now going to courts, I don't think so it's going to be any faster. And arbitration, I think you can forget about it. So now how are you going to resolve? And these are common issues that are coming up. The way look forward, the way I always talk about it is you can forget about taking the adversarial stand now, at least for this particular period of time when we are in this transition stage. We have to take what we call a rights-based approach. We've got to look at a common interest. And to talk about it, we also got to look what people are doing in other jurisdictions. And the first thing everybody is doing is you have to talk. Negotiation and settlement is the best approach you have to take now. And here, forget about involving so-called your various claims situations or in an adversarial system and all that. The amicable, whatever amicable provisions there in the contract, try to use that. And if there are no such amicable provisions in the contract, you can always invoke them. There's nothing wrong with parties doing that. Now, the other way forward is just for your information. During the last 3 weeks, I've done about 3 online mediations, and this is a trend also going on in a lot of other jurisdictions. And online mediation, the way I looked at it, was very fast. In fact, 2 of the online mediations we managed to do within half a day. The other one was within 1 day. And this involves scenarios where, for example, the certification had been done and no payment had been made. And there was another scenario where, for example, the contractor had submitted his application for payment and no valuation had been done. The QS was complaining that he couldn't go to site, he couldn't do any site valuation. And both parties realized that this contractor was particularly very, very desperate for money. And here, as you must understand, mediation is something consensual. And this is where, as I said, the whole paradigm has shifted. Parties must understand. You cannot look at your own interests in a very particular way. You have to look at a wider interest. You've got to look at the interest of how you want to make sure that the job is going on. Now, if you look at main contractors and you look at employers, for example, if 1 or 2 of your contractors were to fall out, for example, even 1 or 2, it is going to adverse your job in the long run. So here, for example, this might appeal to a lot of parties is forget about taking your entrenched positions like we see in adjudication, we see in litigation, we see in arbitration. Now is the time for you all to look for a common interest. Whole thing is to get the work going, get the cash moving, and make sure that the work goes on. As you know, the last thing you want to do is waste your time on claims and disputes and all that. You rather concentrate on the work. So the way forward, I looked at it, and this is actually quite prevalent in other jurisdictions. The way I noticed where the MCO lockdowns have come about is, one is mediation. And here again, as I understand from Mr. Oliver, and master builders have got also a panel of mediators. I think most of them are actually available. And if on a wider sense, PAM has got their own panel, IEM has got their own panel. I understand RSM got their own panel. Okay, worst come to worst, you can have AIC or MMC, for example. And I think the whole idea is what? To do something fast. And the only way to do fast is to go online. And as I mentioned, we have already done 3 successfully, and I'm very happy at least it's settled. Now, the problem people complain about is what? Mediations, if the other party does not, for example, honor the settlement agreement, then you got a problem. Yes, we recognize the problem. Until we get something like what we have in Singapore, Convention on Mediation, where the courts are willing to enforce it. In the meantime, all we need is actually the parties to be cooperative. So mediation is the way forward. Now, the other thing which very interestingly I ended up doing, and which I understand is also being done in a lot of jurisdictions, is fast track expert determination. In fact, the first one I did was about 2 weeks ago. And there was a dispute between the architect and for example, the contractor as to the value of the certificate. So it was very, very specific. There was no expert determination clause in the contract, but parties quickly agreed to one ad hoc one. Okay, and these submissions and everything was done online. There was no need for a hearing, and we could do the expert determination within a matter of about 3 or 4 days. So the way forward, the way I look at it is we have to go for mediation. Most probably we got to go online mediation. A lot of us are doing pro bono. Some of us are prepared for this period to do it pro bono. And once, for example, the MCO is lifted and things become a bit clearer, I think even mediators, my appeal to mediators is also, please give your service. At this instant, I think construction industry, the interest of construction industry and the nation is much wider. You do pro bono. In the process, you also benefit because you also somehow garner experience. So we have a pool of mediators. Okay, it's only thing people so far have not got much confidence in mediation. Okay, and I can tell you the same thing happened when we started off in adjudication and arbitration. And this is where I think you have to rise up to the occasion. You have to look what is lying in for you. Okay, so basically is the way I talk about it. You go for negotiations, try to settle it. If you cannot settle it, try to go for mediation, online mediation. I think here master builders can help out. I think they've got a panel there. Okay, if you really want something very specific and all that, then you go for your fast track expert determination. Okay, there's something else which we used to use last time called dispute resolution advisor. Okay, and here a dispute resolution advisor is also somebody who can help out. Now, the way I look at it, all the professional appointments, if you're an architect, if you're an engineer, or if you're a quantity surveyor, there is a provision in your agreement. At least I know in the Board of Engineers standard form of contract, there's a provision that says that if there's a dispute between the employer and the contractor, the engineer should act as a first line of dispute resolution. In the same way, it is also stated if there's a dispute between the contractor, main contractor and the subcontractor, the engineer should act as the first line of dispute resolution. Now, I think it's high time for you all to relook at those provisions. And if you're an engineer, if you're an architect and QS, now this is a time for you to provide the service. You are supposed to be seen as a neutral. Please act as a neutral. And I think in such a scenario, employers, contractors and all that, please look at these professionals as neutrals. You see? And this was how adjudication also started, like those days. All adjudication was basically done by these people. So now if you cannot do in that sense an adjudication, you can at least do as a mediator, or you can do as a neutral, facilitating some sort of a settlement. Okay, so I think I'm not going to talk too much about it. There's not much time available. I just want to summarize here. We have an extraordinary situation where the so-called conventional adversarial systems, I feel, cannot work. Okay, so I think we should forget about adjudication. We should forget about arbitration and litigation for this period of time, at least for these 3 months or 6 months. Later on, you can take it up. There's no problem. What we need is a quick, rough, some sort of a summary decision. And who are better to do that? Professionals in the field. Sorry, no disrespect to the lawyers. I think these are basically issues to do with money and time. I think all of us can sort it out. You don't have to go into extensive legal arguments. And this is where I think parties, this has got to come from parties, a realization that we have to give this forum some chance, you see. So that's what I'm going to say at the moment. I know at the moment this topic is not much of relevance, most people, because disputes have really not come up. People are still arguing. And in scenarios, it is already coming up and it is surely going to come up. And I can tell you, Master Builders is one of the organizations, I'm not patronizing or what, has recognized this and have given a lot of thought to it, and they've got already the infrastructure and everything ready, you see. And I think please use it, please talk. The whole thing I always talk, keep on talking. Because once you get in dispute, people will never agree on anything. And please look at a wider picture. That's all I can say. Okay, thank you very much.
Thank you, Mr. Harbans. I agree with you. Yeah, actually, mediation among contracting parties is one of the good options to resolve dispute all the while. In fact, it works very well in many other countries. Furthermore, now we are doing mediation online and as shared by Mr. Harbans. Yes, Master Builder has a panel of mediators who are prepared and ready to serve the industry or assisting resolving a dispute. So can always come to us and make inquiry with our Master Builder office. Now, many have spoke on the COVID bill, legal protection to all contracting parties, where Liabilities on non-performance by party involved shall be suspended within a specific period of time and putting other legal procedure in good orders. Kheng Ho is to enlighten us again on these needs of COVID bill this morning. Kheng Ho, if you are ready.
Yes, I am, Fadzli. All right, so everybody talks about this COVID-19 bill, and lots of different industries are pushing for it. So let's just have a little bit more clarity on the situation so that we know more about what we're talking about. So we're going to cover very quickly in this closing session what are the countries that have come up with temporary measures, what these measures cover generally, and we will look more specifically at the Singapore model, and you will see why as we go on. Next, Fazli. So here is a situation, we have got a very fluid situation. I have got a list of countries that have come up with some temporary measures for COVID-19. I cannot be sure whether it is complete because things are just fluid and changing. But as you can see, of course, all of us know Singapore has it, UK has it, Scotland, Ireland, Australia has come up with it twice, Hungary, Sweden, and there are, in addition to this major temporary measures bill, 38 countries have come up with various kinds of export prohibition, including Malaysia. We are now prohibiting the exports of face masks. Next. So what these measures cover generally? Generally, if you go through these various bills, you will see that they cover a very wide range of topics, in ranges from democracy, administration of justice, police powers, physical and mental health. It even deals with death, how to deal with bodies, and it is not limited to economic issues. But if we were to zoom in on the business measures, on the economic issues alone, they can roughly categorize into three kind of broad categories. First, there are all kinds of financial assistance, subsidies, grants, tax incentives, access to easier credit granted to businesses. Number two, there is temporary protection given from legal proceedings of some sort, whether it is eviction from properties, residential or commercial, legal processes, insolvency related processes, insolvent trading. We will talk about it a little bit more when we talk about the Singapore model. And there is, in UK, Ireland, and Scotland, there's some extensions of time given to statutory timeframes related to planning permissions, related to bankruptcy compliances, and even some elections. Next. So let's look at the Singapore model. And why I want to look at the Singapore model, because the Singapore model is possibly one of the most business-oriented amongst all the temporary measures that we have seen. They give relief essentially to contractual obligations, and here you see the types of contracts they've covered. Event contracts, that has been contracts for having exhibitions, weddings, tourism-related contracts, construction contracts, and of course this is something that everybody in the construction industry will be very keen on. Performance bonds for construction contracts are covered. Leases for non-residential properties, secured loan facilities for SMEs, and hire purchase agreements. Next. Now for all these covered contracts, these are the things that the Act says parties cannot do. But let me put a caveat there. The application of the Act is not automatic. That means the Act doesn't come into play unless you trigger the mechanisms in the Act. But if you trigger it, then these are the things that the parties cannot do. One, you cannot commence or continue proceedings in either court or arbitration. You cannot enforce the security. You cannot apply insolvency-related measures like calling for creditors meeting and so on. You cannot commence execution, distress, or other legal process against the property. You cannot repossess goods. So somebody has taken your goods and you have not paid for it, and the title is still with you, you cannot repossess them. You cannot terminate, forfeit, or exercise re-entry over leases due to non-payments of rents. You cannot enforce judgments, awards, and determination, even if you have already obtained it. You cannot call on performance bonds, and you cannot forfeit deposits placed for events or tourism-related contracts. Next. The Singapore model also gives you temporary protection from insolvency. So number one, they increase the threshold for bankruptcy and insolvency. Of course, Malaysia has done that also for the Companies Act. They have increased it to 60,000 Singh for bankruptcy, 100,000 Singh for insolvency. They have increased the time to respond to statutory demands from 21 days to 6 months. We did exactly the same thing, but they did this by an act of parliament, whereas ours was by subsidiary legislation. So there are some questions there whether a subsidiary legislation can amend a principal act, and there will be some issues arising from that. And they have absolved directors from liability for insolvent trading in the ordinary course of business. So let me explain this a little bit further. So if you are a director of a company and you know that your company is insolvent, you're not supposed to incur more debts for the company because you are conducting insolvent trading, because there is a possibility that you are defrauding your creditors because you know as a director of your company that your company would never be able to pay back that debt. So when that happens, a director can be held personally liable for insolvent trading. What the Singapore model does is it absolves directors. It says directors who are not out to defraud, but who are carrying out the ordinary course of trading are absolved from any personal liability for insolvent trading under the Temporary Measures Bill. So what happens if you want to claim relief? So as we said, it's not automatic. One, you send a notice to the other party and you say, hey, I cannot fulfill my contractual obligations. I need some relief from you under this act. If the notice is rejected, you then apply to the Minister of Law to appoint an assessor. So what the assessor will look at, it seems, is that the assessor will determine, were you unable to perform your contracts due to COVID-19? Or perhaps you were already in breach of your contract before then. So if the assessor thinks that it was primarily or materially caused by COVID-19, then the assessor can determine that you are entitled to relief under the Temporary Measures Act. Next. So here are some of the reflections on the Singapore model. First of all, it is extremely business friendly. It is not automatic, it is not heavy-handed, and they use the mechanism of assessors appointed by the Ministry of Law to prevent any abuses. So if a contractor, you are already extremely in delay, you cannot then take this MCO as the get out of jail free card and say, I must have a temporary measure to get out of my own extreme culpable delay. So the assessor is there to prevent abuses of the act. Many features will be very welcome for contractors. For example, moratorium on calls for performance bonds, moratorium on legal proceedings, including winding up procedures. And there are some things that I think could make it a little bit better. One, the law could impose a statutory extension of time for all statutory deadlines for at least the period of the MCO, for as long as the MCO subsisted. You could extend limitation periods. You could extend deadlines imposed by permits and planning permissions. And for licensed housing developers, you have got those sale and purchase agreements with end purchasers. You could extend those deadlines, because if the employer is facing liquidated damages because they have to deliver the end results to the property to the end purchaser on time, you can imagine that they are not going to be very friendly towards contractors because they're going to push for the completion. In a few days ago, I was discussing with, we were having a discussion, and Harbans raised this idea of, hey, there can be a special ombudsman appointed during this period just to sort out the private contractual disputes. Of course, you can always resort to statutory mediation. By statute, you could impose that for a period of 6 months, parties should at least attempt a mediation to resolve disputes dealing with, for disputes involving companies affected by the COVID-19. So these are some suggestions that we can adopt moving forward to push for a temporary measures bill that is not just good for the construction industry, but generally good for business as a whole. Next. And so in conclusion, every business today needs some breathing space and some cash, and a temporary measure to stay the hands of everyone from rushing into dispute may be a very good idea, so that we encourage parties to at least attempt to seek out alternative or better solutions. Because besides that, out of a sense of frustration, insecurity, or just desperation, parties are just going to rush into dispute, and that may not be the best big picture for everyone. And if the mediation, the better solutions, the alternative solutions, if all these temporary measures fail, so what? 6 months later, the gloves can come off and we can be at it again to enforce our rights. So that's all I have. And thank you very much for tuning in. Over to you, Oliver.
Thank you, Kheng Ho. Thank you, Kheng Ho, for sharing on the needs of the COVID bill. Well, our time is overrun, but I think we still have a few minutes to discuss about one or two questions that raised by the floor this morning. And I shall open the following question to all the speakers. So feel free to share your views and suggestions. Now, number one, there's somebody raising up this question. So, taking heed of the current pandemic, are there any changes you would recommend be made to current standard forms of construction contract in Malaysia, especially in the PWD, PAM 2018, or even an AAC 2019 contract? Who should start first? Mr. Rush?
I presume that that these circumstances are extraordinary, which people hadn't contemplated before. So it may be helpful in the next editions of these forms to specifically address this particular situation and make it absolutely clear that it is a force majeure situation.
Anything from you, Mr. Harbans?
My way of looking at it, I think at the moment we should not be looking too much about what is going to happen in future contracts. I think our immediate concern is how I want to deal with the scenario now, because I think situations are very, very immediate, So I know it's a good suggestion. Definitely, I think most forms are going to be amended. People are going to look at it. And with the experience we have now, definitely we're going to incorporate it. But my more concern is the way I keep on getting emails from people is how, with the existing provisions and whatever it is, how we're going to solve the problem now. And after listening to this whole morning, I know there are forms and contractual provisions that don't have, but somehow along the line, I think let's not talk so much about contract at the moment. I think we have to look beyond contract, we have to look, take some sort of a win-win situation, When you start talking about contracts, everybody will dig in their heels. This is my right, I think this scenario is totally different, because the other day I was talking to a foreign professional who is handling a similar kind of problem. He said he was very surprised in their environment, nobody is talking contract. Everybody is trying to see that they are taking it as a big liability on everybody's part, and everybody is trying to find solutions. So let us not divide ourselves into contractors, these, that, and all that. Let's look at a common problem. Of course, in future, definitely we can incorporate all these things. I think it will be a good idea to do that. Thank you.
So it's better to postpone any dispute. Should we have it now? Or even try to mediate? The important thing is everybody to move on together rather than dwelling with the dispute. What you have in mind, Mr. Ong?
Well, I'm just thinking that, of course, what Harbans says is right. Earlier in my presentation, I said that the employer certainly will have to take a commercial and contractual aspect of it into account, particularly the commercial aspect of it, because at the end of the day, the project needs to be successful. The construction work needs to be finished. That's the primary important. If the project ends up in a dispute, to me, the project has failed in that sense. So this COVID thing, if you look at it, this pandemic, it's like 1 in 100 years occurrence. So maybe it's predicted that it will come again. But if indeed there's some change that needs to happen in our contract, is to make it clearer, like what they have in FIDIC, where the criteria for so-called force majeure to occur, it's quite specific, meeting the certain requirements in there. And also to allow for compensation when this sort of event happens, because otherwise you find that at the end of the day, the contractor and subcontractors, when they go on and do the work, they are not there to do it for love. They are doing there for a profit. And if they lose money, then you're going to have that problem as well, on dispute and to find compensation for it. Thank you.
What do you have in mind, Eileen?
Well, for me, other than looking at, of course, the EOT provisions, I think this, difficult period has actually brought up to the forefront. Really, I think what Harbans has said earlier, and even Raj, the need for parties to come to some kind of a solution. I think parties should seriously look at their dispute resolution procedures instead of just always thinking about adversarial kind of procedures. Are there any possibilities of coming up with something more, discussive, negotiation and mediation and things like that? So certainly, I think parties should reconsider dispute resolution provisions with a new light.
Yeah, thank you. Well, okay, let's just look at the next question. It's interesting. What can an employer do to ease the contractor cash flow? I think these are all the contractor wants to know. But I'm sure the client can do something, the employer can do something to assist the situation. Like what HT has said just now, probably can look into the possibility of release some retention money, early release of retention money, or even can look into shorten the honoring period. What else you have in mind, Mr. Ong?
Well, I think this is an unprecedented event, and it requires unprecedented action. And the leadership is important, and the employer, be it the private sector as well, the government sector, needs to take the lead. I have mentioned earlier, somewhere 10 years ago, talking about the increased steel bar price increase, which affected the industry quite badly. And at that particular time, the public sector, the government took the lead on the VOP price. Private sector, some employers came in and stepped in and on an ex gratia basis or on a supplemental agreement basis, given additional money to compensate on the promise that the work is done, is completed, and so on and so forth, and all that. Now, I think that needs to be considered. That needs to be acted upon as quickly as possible, because this remobilization period may not be traditionally what we call 14 days or 7 days, because it may take longer, because our industry, unfortunately, is also dependent on not only legal workers, but also illegal workers, which now, under this current situation, makes it impossible, per se. So I think it is important to take all this into consideration. The workers has not been paid for over 45 days or more, and when they remobilize, there's going to be another at least 2 weeks. So that means 2 months of no payment, and these things all need to come in. And there's going to be a lot of costs involved, particularly on the prevention, screening, delays, disruption, etc., and all that. So, as I said, it's unprecedented. It needs an ex gratia consideration, and the commercial aspect is more important than the contractual aspect. If you want to move forward amicably and not to have, at the end of the day, a dispute in terms of arbitration, court, or even adjudication for that matter. Thank you.
Well, Mr. Harbans?
My comment, coming back to this issue of retention sum, I know in JKR contracts, they don't have it anymore. In other contracts they have, basically it's a contractor's money. Okay, here, in a way, the employer is holding, is a question of risk distribution. In some jurisdiction, as I understand, even in Italy and Spain and all that, I understand that one of the methods they have been using is they have been releasing, you see, normally we release half the retention sum, half moiety at the end of practical completion, the remaining half at the end of defect liability period. Now, to ease this kind of cash flow, after all, it's the contractor's money. Some of the employers in these kind of countries actually releasing half the retention sum earlier to give some sort of a cash flow. Because the employer doesn't have to come up with any money of his own. After all, this is a contractor's money. So this is one solution, okay? Of course, I just want to make one comment. When we are talking about this kind of scenario, is in our generation. Yesterday, I was talking to a contractor who's in his 80s. He faced a similar problem when May 13 happened in 1969. And he told me at that time there was no adjudication, no arbitration litigation. They managed to sort out everything. And they came out of the May 13 scenario much stronger, you see. So if that generation can do, why can't our generation do? Why are we so entrenched, always looking for excuses to claim and fight among each other? So I think the country has gone through that kind of scenario, at least the May 13 and the post-May 13. Okay, I think that was even more an extended period. So I think in this sense, I think we should learn something from our forefathers, how to solve things out, handshake, amicably, and it's a win-win situation. That's all I got to say.
Thank you, thank you. It seems like our time overrun. Well, thank you so much to all the speakers this morning. And as we have covered on the type of EOT consideration, loss and expense, contractual obligation, working during the MCO, SOP, and not forgetting Harbans sharing on the platform for contracting party to seek for common interest to obtain solutions, and Kheng on the COVID-19. To all the participants, yes, we have not solved your financial or cash flow problem. But however, as a way forward, we hope things we have shared this morning can be one of your consideration before you make a decision on the contractual issues. The road ahead expecting to be long and winding. Contracting parties should have faced the challenge together, seeking for mutual and common interests and making amicable solution in order to mitigate damage and losses to the minimum. Now, thank you for attending our first online session. And if there are some shortcomings, I do sincerely apologize. I hope all of you have benefited for this session. Should you think there is a need for us to conduct another or further talk on a specific area, do let us know. So have a good weekend and happy return to office on Monday. Thank you.
Thank you very much.
Bye-bye.
Thank you.
Thank you. Bye.
Thank you, everyone. Bye.